Hello everyone, and welcome to another podcast with Resibuild, your constructive conversations. Today I'm joined by Gavin Hoccom, an expert in construction law, who we're going to talk to about the Gateway 2 process, the Building Safety Act, and whether it's become more collaborative or more of a battleground. Gavin, over to you to introduce yourself.
Thanks, Nick. I'm Gavin. I'm a partner in the construction team at Browne Jacobson. We are a top 50 UK and I law firm with over 700 lawyers working across all commercial disciplines from 7 offices. My day-to-day includes leading our cross-discipline, cross-sector Building Safety Act group, which supports stakeholders at all points within the built environment supply chain to assess and manage the personal and organisational risk introduced post-Building Safety Act.
So thank you for joining us, and we're looking forward to talking about this key and often spoken about issue. So just setting the scene, I thought it'd be good to start off with the looking back at where it's come from. We've obviously had the tragic Grenfell incident. Off the back of that, we had the Hackett report, and the intentions of all of the regulations, the new acts which have come in, like the Building Safety Act, is to make buildings safer, to make it more accountable, and to shift away from that risk shifting culture which was identified by Hackett into prioritising collaboration. So if we could perhaps start off on looking at that, are we seeing people embracing that mindset in that direction, or are we seeing more people move towards a contractual battleground, if you like? What's your thoughts on that, Gavin?
It's a point well made, Nick. You're right. The regulation brought into force by the Building Safety Act was intended to fairly regulate all stakeholders, and for good reason, to address the issues identified as being endemic in the industry post-Grenfell. Our experience, however, is that there is now more conflict, particularly at the pre-construction stage, but in fact prevailing throughout the life cycle of projects as stakeholders across industry seek to hive off the risk associated with the new form of regulation. The building regulations and the high risk buildings procedures regulations, which you're familiar with, have introduced, for the right reasons, a whole swathe of new duties, obligations and requirements that impact the day-to-day of what stakeholders do to design and deliver construction projects. The impact is not just limited to the higher risk buildings. It encompasses all projects within the built environment that are subject to building regulation. And those duties, obligations, those requirements may, on the face of it, appear complicated. But rather than collaborating with one another to implement the project-specific processes, procedures, and systems that might enable all stakeholders to work together to achieve the ambition of building safety for future generations, the initial reaction for many seems to be to do what is possible, often with the support of lawyers, to hive off risk in a contractual sense and pass it down to others within the supply chain.
So, interesting point. What do you feel the driver is for that? Is it a lack of trust between the different parts of the supply chain, regulatory uncertainty, or is it kind of just business as usual, if you like, applying the kind of thinking of Hackett's comments and so on? What's your thoughts around what's driving that?
I suspect that one of the key drivers is misconception and misunderstanding of what the actual impact of the new regulation is in a practical sense. Our lived experience of projects which are underway subject to the new regulation is that actually, if the supply chain is able to work together, managing those day-to-day impacts and practicalities doesn't need to be a burden from a cost and time perspective. And in fact, there's much to be gained by clearly delineating roles and responsibilities within the project team at a very early stage, rather than, as we are seeing, engaging in the back and forth between lawyers of passing risk through disclaimers, exclusions, and limitations, which fundamentally is the business need to mitigate exposure in the usual way. In the context of the BSA and the associated regulation, that is perhaps compounded by the fact that we now have unprecedented levels of exposure to personal risk for those within the governing hierarchies of organisations, whereas the risk may historically have been thought to comfortably sit organisationally, backed by PI.
So in the conversations we've been having with various people in the industry, we're seeing that there's kind of emerging pattern of comments, which is kind of putting people, I guess, into two camps, really. I'd be interested in your thoughts on this. There's those who are engaging early, embrace that approach, working very collaboratively with a number of key suppliers and producing a lot of detail up front pre-Gateway 2. On the opposite hand, you've then got generic detailing because people generally interpret it as being a risk, a commercial risk, to actually do too much collaboration up front. Be interested in what you feel the kind of real world implications are, and if that's something you're seeing as well in there, or if it's not quite as clear cut as that.
It's interesting because one of the common misconceptions we see day to day is that the changes to the regulatory landscape brought into force by the BSA are in some way limited to the employer, the main contractor and the principal designer, when the actual reality is that it impacts every stakeholder, including those construction product manufacturers and others who are bought in at the pre-con stage in order to inform what will become the developed design for each project. It's not uncommon then for the principal designer, whether that's main contractor or not, to go out to market, obtain a range of different options for certain parts of the build, including details, drawings, specifications, etc. Some of those pass by the wayside and others ultimately are incorporated into the project as built. In the context of higher risk buildings which are required to pass through the Gateway 2 process, you're right that there is now a high burden on the employer and the principal designer to ensure that at a very early stage and prior to the Gateway 2 application being made, that there is clarity and certainty as to the details and the specifications that will be incorporated into the works.
And the parties involved as well.
Correct. And one misconception that we have seen in a range of applications seems to be that incorporating generic detailing at the Gateway 2 stage may make it easier to pass through Gateway 2 approval and then begin actually delivering the works, subject to potentially revising that detail. That, though, isn't quite right, because if the regulator has accepted a given design based on a given detail, and there is subsequently a change to that design from a generic detail to a proprietary detail, then at the very least, the parties are going to have to record that change and create an information pack to justify the change and how it complies with the building regs. And if not that, then also not only notify the regulator, but apply for approval to proceed with that change. That will have cost and time implications within the context of the project life cycle, which may have much more significant consequences in terms of impacting any interfacing works than if the parties had simply from the outset at the pre-Gateway 2 stage decided what the detail would be and had committed to proceeding with a specific proprietary or tailored detail relevant to that part of the works.
So giving an example to articulate the point you've just made there, for example, a balcony anchor which passes through a facade would classify as a major change in the Building Safety Act. Correct. It's a structural component, it's passing through a facade, it's probably likely interfacing with other components like the facade, like the cavity barriers and so on. So therefore, designing in a generic detail, which might be, I don't know, an off-the-shelf component, quite low cost, but having 5 of them in there, when you then start looking at it, you might discover that actually in the detailed design stage, that they're under spec from a structural point of view. Once you apply for that, you've then got a minimum of 8 weeks for that to be approved. And that's the reality of the current situation. It's probably not going to be anywhere near 8 weeks for a major change like that. And so what we're talking about here is kind of fixing the details, being mindful of all the particularly life safety and critical structural components, which is what the HSE's focus is being applied to. Otherwise, there's substantial impacts of delays and the commercial risk of that. On the other hand, if you're designing in a standardized component, it's probably selecting a product anyway at that early stage. And it may be that actually one thing we've found is that by working at an early stage, those balcony anchors can be significantly reducing the number of quantity you need, and therefore actually saves money over and above what could be saved from competitive tendering that component later on. If I may move the conversation onto the kind of the thinking of the developers and the clients and contractors potentially, it's understandable that there's a certain amount of commercial tension which needs to be applied to that process in the process of choosing the right people to work on that project. Who are the right people? I'd be interested in your points on that, on kind of how do both suppliers and the customers, the developers, contractors, both see it, that there's a need for that that competitive tension and that close working together in order to build that trust. What's your thoughts on that?
You're right, there is that commercial tension, Nick, for the manufacturer supplier which has invested heavily in cost and resource to develop the design and specification of a solution which will be used in a given application, but has done so at the risk of not knowing whether or not an order will be placed that brings that manufacturer or supplier into the project supply chain. That, on the one hand, linking back to what we said a moment ago, could drive manufacturers and suppliers to provide generic detailing and generic specifications. However, if employers and principal designers are able to recognize that there's a benefit to committing to a given manufacturer or supplier at an early stage, and certainly prior to the Gateway 2 application, then there's a benefit for all. The manufacturer supplier has the security of knowing that they will be brought into the project and should therefore be investing in providing proprietary, tailored details to support the Gateway 2 application. The employer and the principal designer then have the benefit of knowing that there's a greater prospect of the Gateway 2 application being successful, with the regulator being satisfied that there's a clear known quantity in terms of what the given detail and specification will look like. And the issues that we touched upon earlier in terms of change control should also then be avoided, because all parties know what will be incorporated into the build, what needs to be ordered, and so on and so forth.
So there is a lot of investment, and there may be some developers and contractors unaware of the significant costs of fire testing products. I know you work with some door manufacturers, certainly balcony anchors. We do a lot of testing fire. Wise, it's difficult to get the slots. It's very expensive to get the slots, and the testing process needs to be done in so many parameters. So there's lots of investment in product information and certainty at that early stage. There's also a lot of construction products which would the most precious resource the supply chain have is the design of those products. M&E packages would be one of those. Balconies is another one as well. And there's no doubt lots of products like that where the uncertainty of the pipeline currently is placing a lot of pressure on companies, particularly companies. We're lucky enough to have a global various marketplaces we work in, but those who just purely work in high-rise or high-risk residential buildings in the UK, their pipeline might be very, very squeezed at the moment, and having an uncertainty of investing a lot of money up front, but not necessarily going to be able to pick up the work and make the profit later on, would be a huge concern. On the flip side, there's also maybe a lack of understanding in the supply chain that actually without the Gateway 2 approval, the funding might not be in place. The contracts might not be fully signed up with the main contractors, and they're in a difficult position too of actually being able to actually be able to place orders. It's not realistic to expect a main contractor to give a purchase order for £500,000 of design work on something which they may not have from their client either. So there is a two-way recognition that it's not a great position to be in yet, and maybe is perhaps a side effect, if you like, of the massive delays there's been in the Gateway process. But you make some good points there about the kind of the certainty and or lack of certainty around that process. One of those, though, which is kind of controversial, I'd be interested in your expert opinion on this, is PI, of where you have got people working together, assuming there's some kind of initial PCSA agreement or something up front and somebody's designed something. What happens if there is a need to change that? Because the reality is that there will be processes where it may not be convenient. Perhaps the timescale on a project's changed and the capacity isn't there in the factory which was originally chosen, or a company's unfortunately gone out of business and therefore you have to choose another one. How does that piece work from a PI point of view?
Yeah, that's interesting. So we also see this where as part of a VE exercise, the manufacturer/supplier is changed and a broadly equivalent detail is then substituted from the incoming manufacturer or supplier. So this happens frequently, and it has always been potentially problematic if the incoming manufacturer or supplier adopts the design, spec, etc., the detailing provided by the original manufacturer or supplier at PCSA or equivalent stage, and hasn't got the appropriate policy in place to allow that adoption or abstraction of another's design. That's always been an issue. An issue, though, post BSA is that, as we know, the building regs have introduced new procedural requirements which include the duty holder and competency regime. An organisation, such as a designer, will be a duty holder for the purposes of those regulations, regardless of what the contractual matrix may say.
Yeah.
all that needs to happen is that they need to have satisfied the definition of designer, which is essentially no more than they have contributed to the design of the project. There's a real risk then that a construction product manufacturer who provides detailing, who provides design at an early stage as part of a PCSA or otherwise, will be a duty holder within the context of the given project. Even if an alternative manufacturer supplier comes in, then that won't change what the position looks like from a regulatory perspective. In that scenario, both of your construction product manufacturers or suppliers will be duty holders for the purposes of the building regs and will owe certain duties, obligations, etc. in terms of their design outputs. The risk from a PI perspective is that the PI may only be on cover for services which are provided contractually. It might not extend to cover off regulatory risks which essentially apply by default. And there is the potential then in that scenario where you have an outgoing manufacturer or supplier who contributed at an early stage and an incoming manufacturer or supplier at a later stage, potentially during delivery of the project, that employer, principal designer, etc., could leave the could leave those affected by the build exposed if there's an issue in future and claims are brought in relation to the design or the details contributed by either of those manufacturers. With that in mind, there's good reason to ensure that there's clarity, that there's confidence in what the project supply chain looks like, who's involved and when, and that they've got appropriate PI in place to ensure that there can be a remedy in the event of the worst possible outcome post-completion.
So, assuming the example of a company which has ceased trading, where that's being transferred over, you've got from what you're saying there, you've got the PI consideration, but also the legal obligations and maintaining that competent team of designers and people working in the building project. What should a contractor go through in terms of their thinking, due diligence, if you like, to actually make sure that process of bringing on board a new company is actually done correctly?
Yeah, there's probably two aspects to that in terms of ensuring that the position with the previous organisation is resolved. That means engaging with the administrators or liquidators to determine whether or not there is an effective PI policy in place for work which has already been done. As best practice, when having engaged any third party from the outset, contractors should be requesting copies of PI certificates at that stage, and requesting and requiring that those be updated each year when a new policy is entered into. So in theory, if an organisation within the supply chain does fail, that those certificates are already on hand and the policy details are already known to enable inquiries to be made to see what the position will be with regards cover going forward post-insolvency. Insofar as the incoming third party is concerned, the same point applies in order to ensure that that organisation has the appropriate cover in place, but also then ensuring that steps are taken to perfect the contractual position. That could be by essentially requiring that incoming organisation to step into the shoes of the previous organisation by way of an assignment of the underlying contract. That is probably unlikely to be commercially viable. And so it will be ensuring that, at the very least, if there's any pass-through of design from the original party through to the incoming party, that full design responsibility is being accepted for that. In other words, the design is being adopted. And if it is, again, that there's appropriate PI in place. If, though, the incoming organisation's not willing to sign up to that, then there needs to be a reality check around what happens going forward. Because if that existing design isn't adopted or replaced wholesale, then again, there'll be a coverage gap in the event that there's any issues with that design in future.
So, and alongside that, obviously considering that the person who's taking on that and is accepting that contractual risk, if they are, is that they're actually competent to actually be designing that in their own right and can prove that and demonstrate that, because that's obviously a mandate through the Building Safety Act.
We've nodded to the new procedural requirements of the building regulations, and assessing competency is a key part of that, which, again, our experience is that many stakeholders are overlooking the importance of assessing competency and the fact that the obligations don't begin and end with the employer who's appointing a principal designer and a main contractor, but apply at every point within the project supply chain and continue throughout the delivery of the project. So the main contractor needs to be assessing the competency of the subcontractor. The subcontractor needs to be assessing the competency of the manufacturer, who's also then carrying out design and install. And that occurs not only just from the outset, when the project team is being formed, but also then as new organisations are being brought in or replaced from time to time. The misconception perhaps seems to result from the fact that there's only, in reality, a few sentences around competency within the building regs.
Yeah.
But of course, the good work that's being done by others in industry is demonstrating how wide-reaching and how widespread the assessment of competency needs to go for all stakeholders.
So one of the obligations on the duty holder, the principal designer, is the collation of the design information and holding a digital golden thread of that. What is the potential risk profile for construction product manufacturers contributing to that information and in that early stage of the design?
The golden thread obligations that apply in relation to HRBs, as you say, are broad-ranging and cover off essentially all aspects of the details and specifications that go into the build. And that's the right thing, because we know from Grenfell how critically important it is to have that golden thread of information for every building, not just HRB, so that we can understand what has gone into that build, what has informed its design, and what risks does it present. And in the event that something does go wrong, having that information to hand enables industry to develop the very best response to the issues.
We've talked about the project. We've talked about from a contractor's point of view and switching out suppliers and so on. If we perhaps come back to construction product manufacturers, obviously there's some considerations around what happens if their design is taken and applied to a project. How does that affect the PI piece? But there's also considerations relative to specific provision of specific information and so on. Talk us through those 2 points.
Yeah, so in relation to higher risk buildings, there are duties, as you know, in relation to the maintenance, the golden thread of information, which the principal designer and principal contractor take responsibility for during the life cycle of the delivery stage, in order to, on completion, be able to hand over an electronic repository that contains all information relevant to the detailing and the specification of each part of the build. We know post-Grenfell how critical having access to that information is, because it can inform all manner of different responses in the event of an emergency or emerging defects, both in a substantive sense in terms of remediation works, but critically to inform the response of emergency services. The breadth of requirements in relation to the golden thread mean that the detailing, the test data, the specifications, etc., that are contributed by construction product manufacturers as part of the design phase or the delivery phase will almost certainly, or should almost certainly, find their way into that golden thread. There may be some within industry on the manufacturing side that feel that's another reason to be nervous and perhaps to drive again the use of generic detailing and specification, which we've already discussed. The reality is, though, that what's critical is ensuring that there is visibility on what has gone into the design, what has gone into the detailing, and ensuring that there is visibility on performance of given products in given applications and interfaces. It may not be relevant during design and delivery, but it's a complete unknown whether at some point in the future it might be safety critical to know how a given product interfaces with other products, interfaces with the build itself, or performs in certain situations. It's important then for construction product manufacturers to be engaged in the golden thread process by the principal designer and the principal contractor, and to themselves voluntarily provide as much information as they can relevant to the design and detailing of their part of the work.
Moving on to looking ahead, some of the positives out there. We know there's lots of delays, lots of uncertainty, lots of challenges, and it's always going to be this case when such a major shake-up happens, but it was probably long overdue, or it was long overdue in the industry. So we've talked about the BSA, the gateway changes and so on, and what the intentions are. But what's your conclusion on the kind of the topic of whether it's become more contractual, and whether that is actually just the current state, or whether directionally it's likely to remain that way?
There's understandably a significant amount of nervousness around what risk looks like in the regulatory landscape introduced by the Building Safety Act. On the one hand, you have the Act, which is a very lengthy piece of legislation, supported in England by a further, 5 to 6 pieces of secondary legislation, which in turn impact the Building Act, the building regulations, the Defective Premises Act, and a lot of the commentary has focused in industry on 30-year limitation periods and risks for officers within organisations that could mean heavy fines or even imprisonment. In other words, the commentary has very much focused on the most negative aspects of what the new regulation looks like. But taking a step back, the ambition is to drive building safety now and for future generations through the creation of a regulatory framework, which frankly is representative of what we might reasonably have been expecting all stakeholders to have done anyway, to collaborate, to ensure transparency in terms of detailing, design and specification, to taking ownership for the delivery of each organisation's constituent parts of a build and ensuring then that there are records to demonstrate that what has been built complies with the regulations and with what has been approved by building control. None of that should really come as a surprise, that that's what, from a regulatory perspective, industry is now required to deliver. Unfortunately, when lawyers get involved at the pre-con stage and are rightly advising clients on the risks that they may face, whether they are on the employer side, main contractor, PD, etc., it's fair that the parties who are on the receiving end of that advice will want to start to think about how they might manage and mitigate their risk. That doesn't, though, mean that the answer is to seek to avoid that risk by passing it into the supply chain. In fact, the regulatory risk cannot ever be contracted out of. That regulatory risk applies to all stakeholders by default, no matter what clever wording the lawyers might look to incorporate into a given contract. With that in mind, but also the ambition of just wanting to do the right thing, stakeholders might do well to accept head-on their role and their responsibilities in relation to building safety, just as many have done over the years in relation to CDM and fire safety. Building safety shouldn't be treated any differently. If all stakeholders can accept those roles, those responsibilities, and the corresponding risk, and focus efforts then on collaborating with the supply chain to ensure projects are delivered in the right way, in accordance with the new procedural requirements of the building regs, and where applicable, the higher risk buildings procedures regulations, then the impacts that we've talked about in terms of cost and time should start to fall away. And with everybody doing the right thing together, the risk profile necessarily reduces, because things shouldn't go wrong.
So you make some really critical points there, Gavin, and I fully agree. The collaboration is essential to that. So there are lots of positives, and there are some really good companies who have adopted these processes and are benefiting from it by streamlining that construction process. There is a lot of money to be saved, actually. But you know, this is also not a new thing. If you look at the most successful construction projects which have happened, a lot of them have been because of early stage collaboration. And you know, imagine the Channel Tunnel when it was built and the two teams not collaborating. What mess that would have been, right, if it hadn't have had that collaboration between the two countries. And I think, you know, that's not a new thing. That was built a long time ago, but there's lots to be learned in construction industry about the benefits of collaborating at an early stage and making sure that actually you're building in long-term benefits, not just designing out the risk until the last possible moment when you need to sign a contract. So very interested in your key takeaway for this, Gavin, for the audience.
The key takeaway for me is, notwithstanding the Act came into force mid-22 and we're approaching the 3-year anniversary of the Act, albeit I appreciate not necessarily the regulations coming into force, there remains a lack of knowledge and understanding within industry of what the Act actually means, which projects it applies to, and at a high level, what it means for organisations across the sector. To any organisation that hasn't already ensured that it's management teams have attended CPD and online learning around the Act and the new regulatory landscape, then that has got to be a critical next step for that business to ensure that it preserves its place within the supply chain and is able to responsibly manage the delivery of its projects, no matter where it sits as a stakeholder, to ensure that we can all achieve our ambitions for building safety. It's only with the benefit of that knowledge and understanding that organisations can then successfully collaborate with others within the supply chain to develop out the project-specific processes, procedures, systems that are required to ensure compliance from the pre-con stage through to completion and beyond.
So a point very well made there, Gavin. And I think the critical thing across the industry is enhancing that working together, enhancing the learning, as you say. I know Resibuild hosts various different formats of events and information and learning, whether it be white papers or seminars. Sapphire also are shortly to bring out a Building Safety Act and the Gateway 2 guidance CPD as well. So there's lots of good information out there. It's critical that we keep learning because our interpretation and understanding is only going to be enhanced, and there's very few new build projects which should pass through the Gateway 2 process at the moment. Gateway 3 is likely to be the next stage of learning. We can't leave it there, or we're becoming outdated in the thinking, aren't we? So with that point, I think it would be good to wrap this up. And to the audience who's been watching, thank you for joining us as we've talked about the Building Safety Act, Gateway 2, and the challenges around that, and whether it's become more collaborative or whether it's become more of a battleground on there. There's obviously pockets in both areas, as we've talked through. For now, goodbye from us, and we look forward to seeing you on the next Resibuild podcast of Constructive Conversations. Thank you and goodbye.